Hi guys, it's Kathy. I hope you're doing well. Oh, yeah, you guys are all early today. Mods are swearing in chat. Oh my gosh, I don't know what's going on. Did I spell it wrong? I hate thumbnails and I hate descriptions. Yeah, it's in the thumbnail. It's staying. I'm not redoing it. Guys, I don't know what happened. I think I ordered a blanket from somewhere. I don't know where because I don't remember ordering the blanket. I just don't. But I got a blanket in the mail today. It's like it's like this tiny little scrap of fabric that I have 100 of laying around the house. Maybe it was Timu, but it's not even enough to cover my boobs. So do not listen. Buy stuff local. Don't order online. It never works. But I got bad news for you guys. I got bad news for you guys. My daughter, my daughters went shopping today, and I came here to start my live, and look what they got me. They got me the latest Percy Jackson book. So I'm still gonna stream, but I can't wait to read that. I can't wait to read that. I'm still gonna stream. Don't worry. I'll read that really, really quick. Tape measure. I don't need a tape measure. It's like 3 by 2. It's called a book. A book, Fozzie. A book. I'm so excited. If you haven't read any of the Percy Jackson books, they're really good. Not just for children. I don't even think they're really for children. They're more like tweens. Like little less than teen. All right. I'm going to start with this one. No, I'm going to start with. I don't know what to start with. Let's just get. Oh, I didn't share my screen. I'm going to start here. We're going to Indiana just for a quickie. This one's really, really quick. We told you to go to the hospital. We told you. We all said it. Yeah, we said go to the hospital. 5 days. Oh, no, just no, no. Just throw me out back. I do not want to be in the hospital for 5 days. No. I'm so glad you're home, JoJo. They're really good. You should read them. They're really good. What do you mean not tween? It is. It's not like for. It's not like for little children, and it's not quite for like teens are too cool for stuff like that. It's for tweens. I didn't realize comments were still going. Jojo, go drink some water. Go drink a big glass of water, Jojo. I'm gonna keep telling you that. It's not, Bobby. It's not. Yeah. Drink some water before you go to bed. Where is it? Where is it? Where is it a bad word? I need to know. Hold on. I'm going to Google. tween, short for teenager. Tween. And it doesn't say it's bad anywhere, even on Google. Pre-adolescence. Nope. Nope. Sorry, Bobby. Is that a bad word? Oh, okay. Sorry, we're going to go here. Oh, I just.
State v. Aaron Lemons, Jr., 2404 CM 839. Subject status. Are you Aaron Lemons, Jr.?
Yes, sir.
Home address, please.
725 Indiana Avenue, Michigan City, Indiana,
La la,
Date
I
of
do
birth?
love it.
January 9th,
Nice.
1984,
How old are you now?
40.
40.
Didn't remember.
Well, it's not something you necessarily think about all the time. The older you get, the less you think about it. Well, then you get to an age you start thinking about it a lot. All right, driving while suspended, you were here in November, the judgment out of Washington hired an attorney for this.
Yeah, okay.
Trying to get that taken care of?
Okay, look, I ran into like a roadblock with I hired Victoria Bain, and she just informed me today
That was your problem. Never hire Victoria.
that the court there in Walkerton is only operated by fax, which is, I guess, or something which is gonna make the process a little longer. She told me to ask uh for at least March date for here, which will give her time enough to take care of the Walkerton thing, and then that is the only thing that's holding my license up. Once I could get that defaulted judgment situated, I will be able to go to the DMV and get my license. So, I was basically, I basically begged the court for enough time to handle that. So
So here's what I'm
I'm
gonna
looking
do.
March or maybe.
I'm not gonna set it out that far. I'm gonna set it out 30 days. You
Yeah,
tell.
it's not gonna be
Hold
done.
on,
Okay, sorry.
let me finish. You tell her what the new date is. She can ask for additional time.
Okay, but she is not representing me here. She's not representing me in LaPorte County.
Well, I'm not gonna set it out 3 months on hearsay, so,
It's not, I mean,
well, it is.
I'm asking.
I'm giving you 30 days, sir. Hang on, we'll give you the date. You don't even know when it is yet.
January 13th at 1:30.
He was not pleased at all. He thought he could just ask for a couple months and get it. Security's here. All right. This girl is special. Very, very, very special. Guys. If she's crazy, she will give you signs early on that she is crazy. I know for a fact that crazy just doesn't show up a year later out of nowhere and you're like, whoa, where did that come from? No. You start getting signs real quick that she's crazy. If she's crazy, leave it alone. Just leave it alone.
Sentence for up to 180 days in jail. If this is a first or second conviction, or up to a year in jail if it was a third or subsequent conviction. Do you understand that as well?
Yes.
Is there a waiver or stipulation as to the factual basis in the new case, Ms. Moran?
Oh, we agree on it.
and there is a stipulation to count 3 in the revocation complaint. Other than what we've talked about, Ms. Slade, have any promises or threats been made to get you to plead guilty today?
No, Your Honor.
How do you plead in 24M 3074, guilty or not guilty?
Guilty.
How do you plead in 23M 1698 to the violation of probation, guilty or not guilty?
Guilty.
The court will accept the pleas, make a finding that they're knowingly, intelligently, and voluntarily made, will go to immediate sentencing and resentencing. Mr. Shields?
Your Honor, I think given these 2 cases, in which Ms. Slade will now be on probation for, it sounds like from my talk with, Ms. Moran, that there's another case as well where she'll be on probation for. Hopefully she'll get the treatment she needs and can turn things around this time, Your Honor. I think
Okay, thank you. Ms. Moran?
Yes, Your Honor, I was asked that the court set this as an appropriate disposition. Ms. Slade does expect to resolve her other kind of cases with probation, and she's looking forward to getting to probation, ultimately putting this behind her and having some justice behind her. Additionally, Your Honor, I was asked the court not to impose any additional fines, noting that she will be on probation with an irrevocable bond and will have probation class. Okay, thank you.
All right, here we go.
Ms. Moran, are there other holes that she's gonna have to deal with?
There are, Your Honor, she does expect to bond out, but is not exactly sure on the timeline. It's possible that she may get transported first, before bonding out. I would just ask for a little bit longer in terms of taking probation.
Thank you, Lala. I love your name. Was it True Blood? Lala? Yes. Sorry, it reminds me of True Blood.
And then where does Ms. Slade reside? Where is she hoping to ultimately do probation? Where do you live, Ms. Slade? Is that okay to ask her?
So I'll be going back with my brothers back at the 4599 South Low Boulevard. That's Denver, Colorado 80236.
Okay. And do you have any cases out of Denver?
She looks like that that girl from Shameless, but I can't remember any names on Shameless. The girl with the littler one that grew up.
No new cases out of Denver. I have a PR bond out of Jefferson County for $500, and I have an Adams County warrant for probation, also revocation, that I have a $1,500 bond on. So I'm hoping that once this decision is over, I'll be going to Adams to take care of Adams, or be bonding out of Adams so I can be home.
Okay. Well, it's a little challenging to figure out where and who's going to supervise you ultimately, but you at least have a good plan of how you're going to get all these resolved. Is there anything else you want me to know, Ms. Slade?
I just want you to know that, like, I know I just was here a year ago, but like, I just, I got into a couple completely toxic relationships, and, they were really, severe, abuse and more mental, emotional. So, I'm no longer in those relationships anymore.
I am positive she was the toxic one. I am positive that she, in fact, was the toxic one.
And, this is something that I'm not trying to continue and keep heading down this road. So I just want to.
Marty, that's what I would do. Lord of the Rings, Harry Potter, Percy Jackson, the Prim, come on, help me, Hunger Games, and Divergent with 4, I don't remember, but I would put my chair in the hallway, and, the rooms were all around me, and I wasn't reading, Hop on Pop and Fox and Socks, even though I love Fox and Socks. Yeah. And I would read to them every night for a long time. Stop. Don't do that.
Another opportunity at probation. I was on it for, quite some time and doing well on it. And then the Adams popped up, and, so trying to do 2 probations kind of made it difficult from 2 to Adams and Douglas. So that was overwhelming. And I just want you to, know that was those issues. But today it seems like I have more support, and I'm no longer in those toxic relationships, and I'm just trying to make a better future and just, move forward with this part of my life already.
Well, I wish you well. I hope that goes as planned for you. The court accepts the dispositions in 24M 3074. The conviction will enter for theft, less than $300, which is a petty offense. You're sentenced to 12 months of supervised probation. I'm not going to impose any fines, but there are court costs and fees. In addition to standard terms and conditions of probation, you're going to complete a drug and alcohol evaluation and follow treatment recommendations. You'll also do a theft class. There's no restitution, so this will be a final sentencing order. In 23M 1698, probation, the court accepts the admission. Probation is revoked and reinstated for 12 months to run concurrent to 24M 3074, and that you'll comply with standard terms and conditions along with previously ordered conditions. I'm not going to impose any fines. In that case, any new fines, whatever was previously ordered, you're still responsible for, along with court costs and fees. You're going to be ordered to report to probation within 48 hours of your release from custody or the next business day. So if you get out on Friday at 5 o'clock, you'll have until Monday to get to Douglas County Probation, okay? And then talk to them about what is going to make the most sense with your other cases for where you're supervised. And they'll try to work through that with you, okay? The court gives probation the discretion to, or the ability to change venue of supervision if that's appropriate without further order of the court. Good luck to you, ma'am.
Thank you. Thank you, Your Honor.
That concludes that matter.
Thank you.
Thank you.
Judge, she was in toxic relationships. That's the problem. It's all these guys that she was with. They were the problem. And then she was in probation for 2 different courts, and that got really confusing. You know, the one saying don't do drugs, the other saying don't do drugs. Which one does she listen to? I also got as a tip, I got it yesterday, I think. The day, I don't remember when I got it. It was within the last couple days. I got a lottery ticket as a tip, and I won $5. Yay. All right. Now let's go to Indiana. And it starts out, you're going to hear some, woman crying, begging the judge. So it starts out with victim impact statement.
So
I'm sorry.
I shouldn't be hearing necessarily
I'm
about.
sorry.
plea
No, I'm
offers,
not in
etc.
favor of this particular plea because there's no assurance of any kind of therapy, any kind of anger management, any kind of medication management. When this first happened, and the very first day that I went to the prosecutor's office, I begged them to have me remand him to the VA. Can't have the case because that's where he needs to be. He doesn't need to be in jail.
Thank you, ma'am. Anything further, Mr. Langowski?
No, Your Honor.
Mr. Bernal?
I have no questions.
Thank you, ma'am. You can step down.
Thank you.
Would you like to submit the written statement you have or keep that for you?
Can I keep it?
You can keep it, yes.
You, sir.
You've read it into the record and that's sufficient. Mr. Langowski, help me understand the details of the plea and how it was arrived at.
I think Mr. Burdall can answer that question better than me. I did not handle the negotiations in this.
My client wanted all jail time, and then he could leave the state. That was is what he wanted to do.
And the misdemeanor treatment?
But that was negotiation with Mr. Aldridge.
Okay. That's good.
Well, Your Honor, I mean, it was, I guess, due to the nature of at the time, family didn't want him arrested, didn't think he, as she already said, didn't want the criminal place where they wanted to have their child, and that a service would be better for him. But I suppose that's where the misdemeanor treatment came from, Your Honor. Out of character. And my client, though, wanted to just be able to, instead of staying around here for another 500, well, there was an amount of time that they stayed around, he wanted to be able to leave and go back to where he had been prior, because he did not live, and he was not living in Plymouth at the time when he got arrested. He had come back from where he was, according to my communication with him, and he wanted to go back to.
Just so you know, every single word he is saying is making the judge more angry.
Where he was from.
I will also note on the previous plea that was offered, there was back end misdemeanor treatment.
Mr. Riddle, anything further?
I suppose the difference between the back end treatment and the front end treatment, the back end treatment, they were back to do the probation time, front end treatment because there was no probation time to do. So either way. And then she would have to come back, but she wants to leave.
Okay, the judge is gonna create the show in a second. Just let the lawyers finish.
As far as I can tell, Your Honor, has been relatively a good person at the Orange County Jail, and not a lady in recommendations from the.
Damn it. I had a special beer ready for this stream and I forgot. I'm gonna play this, but I'll be right back. Be good, okay? Please, no drama for 2 seconds.
Report indicates that the recommendation would accept the plea, Your Honor.
It noted in the pre-sentence investigation written report that he had no conduct violations, which you do commend. I think that's what you're referencing.
Yes, Your Honor.
There were two things that piqued my interest about this. First is when I established the factual basis, I asked Mr. Kersey who that person was, because I did not know whether Elizabeth Kersey was a sister, girlfriend, wife. I had no idea. And then when Mr. Kersey answered that was my mother, I was shocked, because no child should treat their parent in that fashion. No individual should treat the elder in that fashion. And so before I heard the statement, I was relatively concerned about the charge, treatment. I do appreciate the fact that under the theory of the misdemeanor treatment, he would receive near the maximum sentence for that misdemeanor. But then I hear the statement of the victim. And I'm not convinced that it should be accepted. And so therefore,
Your Honor, okay. I mean, I see what the victim wants. My client's just going to, according to this, he's just going to sit his time in jail. So nobody's going to get what they want. They're going to actually get not what they don't want. I don't think it's serving a purpose, but it is up to the court to make the decision.
not really making a decision about what the sentence should or should not be, but I don't believe misdemeanor treatment is appropriate. So therefore, rejecting the plea. Be considered for trial, but I'm not going to accept the terms of a misdemeanor plea when the victim is the defendant's mother. Alternatively, give you an option to renegotiate with the state. What would you like to do, Mr. Burrow?
For the state.
How long would you like to do that?
It's gonna have to be like that.
So 30 days?
Yes, Your Honor.
Okay. I can easily give 30 days. Let me double check my calendar in January to see when you are planning on already being here. And then I will select one of those days.
Assume the position, both of you.
I have you down for January 16th. Alternatively, we could set it for the 9th. You were due to be here at 9.
But 16th is fine. No, good. Really great, Your Honor.
If you need a different day, provide a different day. I would just note you already have the status hearing.
We ran into this yesterday, if I recall. It's just the 9th is technically, I guess, the better days because the other ones are.
Lights range. Hello. Jimmy Hoffa might be here, but my glasses aren't. Okay, I got 2 special beers for today. This one is from Big Dog. It's 9.7%. It's a golden strong ale. And it's cranberry. It's for holidays. I can't remember what it is. I know one thing is cranberry. I like it. It's good. This is from a neighboring brewery, Trogs, which is pretty big here. They sell Trogs in like beer stores. This one though, cherries and honey. It's another Belgian, but it doesn't. It's a spicy Belgian. That's what they call it, a spicy Belgian. This one is a red ale, and this one is not. It's not pale. But this one is 11%, and that one is 9.7%. So, because I knew I wanted to do this stream right, so I knew I didn't want to go with 4% beers. No, you shush. Yeah, it's Christmas. At Christmas, the cranberries come out in the beer. Okay, so that's what they told me. They said people either love this beer from Trogs or they hate it. I have a suspicion. I have a small suspicion that I'm gonna love it because it's beer. We were so busy. This is what I heard all night. We were so busy. I was pulling tables from the party room out to cram people into corners tonight. We were so busy. I yelled at one of my customers, I'm holding a tray of beers. And she's like, can I put my food order in? I said, no, I'm holding a tray of beer. I'll be back. I don't usually yell at customers, ever. But this is why I drink. What are you, oh, for Bookshare. Yes. That's really good. I like it. I can taste the cherries. This is really good. Okay. Yeah. Mad Elf, guys. The cherry one. Mad Elf. You can order it. I'm sure you can. This guy yells. So I'm just telling you now that in the next clip, we've seen him yell a lot more than this one, but he yelled, so I got it.
Thank you. The court does find Mr. Walker and Ms. Jackson have executed in open court the written waiver. Court finds the defendant's change of plea to guilty of the probation violation complaint, in this case to be knowing, voluntary, and intelligent. The court will accept the guilty plea, and I will therefore find him guilty of having violated his probation
Good for
in
you.
this case. Okay, Ms. Jackson, is there anything your client would like to say at this time before I impose sentence?
Yes, Your Honor. My client has been a member or participant of the renewal court here in this court. He strongly desires to continue his treatment and progress in that renewal court. He believes that it has been a help and wishes to continue to receive those assistance. He has been working with supportive employment, trying to obtain employment. He plans to continue to work with them to find some sort of employment that can be maintained. Additionally, he has expressed to me that he's had some transportation issues before in the past, but he has taken the steps to make sure that he has obtained transportation for anything or assistance in transportation, to make sure that he is actively participating and following through with all the requirements of the renewal court as well. With all of that being said, he is asking that the court allow him to maintain his progress in treatment in renewal court. As I believe he did complete a reassessment or another assessment last Friday on December 20th, to where he was told that the recommendation was to continue with this treatment, and that's exactly what he wants to do. So if the court could consider all those things, we are asking the court to just maintain him in renewal court. Thank you.
Thank you. Mr. Walker, is there anything you would like to say at this time before I impose sentence?
No, Your Honor, I would say that. Just that I would like to continue my progress in renewal court.
Okay. Ms. Lamer or Officer Benoit?
I'll defer to Officer Benoit, please.
Thank you.
Thank you, Your Honor. I would just recommend that we accept this time served as an adequate consequence of his probation violation. Recommend that he continues the treatment through the renewal court and possibly increase individual counseling sessions through CCC.
Okay. What exactly did you find? I mean, I know you testified at the preliminary hearing, but can you reiterate for us what you found?
Yes, Your Honor. So when we located Mr. Walker upstairs, we were able to locate and confiscate the following items: an airsoft gun with the label scratched off, a box of syringes, 3 of which contained blood residue, which was confirmed by Detective Cleveland, a THC vape labeled Lost THC, forbidden gelato in a safe, a 200-gram canister of nitrous oxide, an empty vial labeled Gorilla Piss, defendant stated it was a testosterone substitute, an empty container of THC syrup, which was 3,000 milligrams, a box 5-gun double-edged safety razors, a package of Egyptian blue lotus flower. It's not listed as a controlled substance in the U.S., but it's not approved for human consumption, nor is it regulated by the FDA. And that was the majority of all the items that were confiscated.
Thank you. Well, Mr. Walker, that's evidence of huffing. You know what huffing is?
Yes, Your Honor, I do.
Why are these items in your bedroom?
I made a dumb mistake. A lot of the stuff, the package of razors I did bring home with me from Turning Point, they were in a gift basket. They were for my razor, and that room was for storage for a while, up until maybe 2 weeks before then. But a lot of the stuff is just because I was making dumb mistakes, and I decided to have them in my possession.
What does that mean? You were making dumb mistakes and decided to have them in your possession. I don't understand what that means. I want honesty from you. You wrote me a letter. I didn't read your letter because I'm not allowed to read letters before I take a plea or sentence you. I want to hear from you what you did wrong.
Okay. Yeah, I admit I was taking testosterone substitution and peptides when I was working out a lot, so they would boost me in the gym, which was wrong. That was what the vial he found and the syringes were mostly for. And I was using the nitrous oxide and the Blue Lotus flowers. I was using, they had been sitting there for a while, but before I was using them for tea, because I had read that they had good properties for them. But yes, I was using everything that was in there.
Up till when?
Up until I stopped working out, maybe a couple weeks to a month after I had lost my job, because I had lost my gym membership. So up until then, and I was using them for maybe about a month and a half to 2 months.
What did I tell you recently about you during a renewal court hearing? You remember what I told you about the way you looked?
That I had lost a bunch of weight, and that you saw that my anxiety was up very high, which it was.
Did you, what you just told me, what you just admitted,
$20 is 20
which
bucks.
I appreciate, did you tell that to the person who assessed you on December 20th?
They didn't really ask, but I did tell them that I was using so the sports enhancements. That was the main thing that I was asked about. And I told them that, yeah, I was in possession. She asked me what I was in possession of, and I told her all those things.
So, what do you consider your sobriety date to be?
I would say from my drug of choice, October 14th, but I would say from counter performance enhancing substances, I would say up until about the month after I lost my job.
Which would be?
That would be,
You forgot to say pss, 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 pss.
that was August, I believe, sir. Or right before then.
I'm reading this report. I don't see any admissions. Reports the paraphernalia was old. It was in a room used for storage. He reports no failed drug screens except one, which is for alcohol.
I'll risk it, Anna. I'll risk it.
He reports it was returned questionable from the lab, and the judge gave him a warning. So you were drinking alcohol?
No, sir. I just told her that I had one that was positive.
He insists he has not consumed any alcohol and was investigating as to how the drug screen was positive for alcohol. Reports he has been sober since October 24th of 2023. Reports that he is engaged with Matt and has been, reports he is engaged with community counseling, reports stable housing with father, reports child. Yeah, I don't see any admissions in here about what you just admitted to me. Did you read anything in there about an admission?
No.
So you told the assessor that you were using these items?
That's what I was using, the performance enhancers. Yeah, I also am not sure why she said October 24th either.
It was October 24th of 2023, which would have been your original sobriety date. That's what she said.
That's what she said.
Was there someone in your room when the officer arrived?
Yes, I had a friend with me that stayed the night.
It
If you had-
hurts.
You don't have to
It
give the
hurts
name,
right here.
officer, but
It hurts.
is this person of interest to you?
She's on probation with me as of 18 November 2024, Your Honor.
Did you report that to us?
No, I did not, sir.
You know, this renewal court program that we have, it's very intensive. It's like, you know, it's ultra supervision. And what have I told you throughout your
Elite, I'm so sorry. I'm so sorry. Listen, time, just minute by minute. Just don't choose no this minute. And then when another minute passes by, choose no. And then the minutes will get longer. The time in between will get longer. Time in between those bad parts. Yeah, freaking Ravens.
participation in your program about honesty?
That was compared to that.
I don't know if your living situation is appropriate. Maybe not residential, because the assessor didn't think that residential treatment was necessary. But perhaps maybe sober living. Maybe a different situation for you is in order, because it isn't working. I'll leave that for the treatment team.
If you do, all the shit you're going through right now, you're going to have to go through it all over again. So go through it once and don't do it again, because then you're going to be in this mess all over again.
Okay. I'll continue Mr. Walker in renewal court. I will give him credit.
All two of them, Robert.
He had originally, before this, he had 100 and... Just had it here. Bear with me, I'm sorry. He had 166 days that were suspended. I will give him 4 days jail credit, so I will suspend the balance of 162 days. I'm ordering that I'm going to extend his probation for 1 additional year. I think that's the maximum I can give him. I've already extended it before. Yeah, no, it isn't the maximum, but I will extend it for 1 additional year. He will continue in renewal court and comply with any recommended course of treatment in renewal court. And the renewal court team will make the determination of whether your current living situation is appropriate. I'm not going to order you into sober living now. That's not for me. That's for the renewal court treatment team. And you're just ordered to continue to comply with all of your treatment recommendations, as well as, which are, by the way, at Community Counseling Center and Signature Health, and comply with all the requirements of renewal court. Look, Mr. Walker, I don't want to show my cards too much, but if you're back in here again on another probation violation, you're facing 162 days in jail, and I'll kick you out of the program. You know, you're a young man who needs this program, and you better kick it in high gear when it comes to this diploma. What did I hear last time? Oh, I can only take one class at a time. Yeah. You've been dragging it on way too long. You better start kicking it in the high gear. I want you to have a diploma quickly, soon, because you can do that. One
Anthony, she's in Australia. They're a day ahead of us.
more time. One more time. Anything further, Ms. You have a right to appeal. You have a right to appeal without cost. You have a right to have counsel appointed on appeal without cost. You have a right to have documents provided you necessary to file an
But he, in fact, won't kick it up a notch.
appeal without cost, and you have a right to have a notice of appeal timely filed on your behalf. Anything further, Ms. Landner?
No, Your Honor.
Officer?
No, Your Honor.
Ms. Jackson?
No, Your Honor.
Okay, this matter is concluded. Thank you.
Hi, guys. How are ya? Hi, guys. It's Kathy. I hope you're doing well. I said I feel bad for talking shit about this blanket because even though it's only this big, it's really warm. It's really warm. I like it a lot, actually. Thank you, drunk Kathy. Thank you. Okay. I still don't remember ordering it. Like, I really do not remember buying a blanket. Okay. I'm not singing. This next clip is called One Pill. One pill. This guy had one pill. All my towels are bigger than this blanket. All of them. Probably my hand towel at the sink is bigger than this blanket.
May, Your Honor.
All right, please proceed.
This is Dawson County unindicted case number 2024 PI 0645, State of Georgia versus Adam Josh Callahan. Mr. Callahan will be charged with one count of possession Schedule 2, that being an oxycodone pill. Counsel, we waive formal reading of the accusation.
Yes.
And do you stipulate to a factual basis?
Yes.
For facts, Your Honor, law enforcement was called, and this is an open plea, Your Honor.
Merry Christmas, Kiki. Where's Kiki? Donald, where? Tell Kiki we said Merry Christmas.
Law enforcement was called out to a suspicious person behind a gas station on Highway 53. When they arrived, they made contact with that person that the store manager was complaining about. It was the defendant here, and during a pat-down search, Terry search, they found a single pill of oxycodone, as well as a little bit of marijuana, but since we can't prove that, I've dismissed it. The state's recommendation is going to be 3 years, less than any time he's already served. We'll deem that served. A balance on probation with a $2,000 fine. We're going to ask that he report to felony probation and ask for 40 hours community service, day reporting center, a Fourth Amendment waiver, specimen admissibility, records release, the substance abuse evaluation, and any recommended treatment, diploma, GED, or proof of full-time employment. He's to provide a DNA sample, avoid alcohol and drug use, verify prescriptions, random drug and alcohol screens. Primary reason for our recommendation, Your Honor, is his criminal history. Starting in 2003, we have misdemeanor marijuana, theft by shoplifting in 2003, obstruction in 2003, battery FVA in 2007, misdemeanor marijuana again in 2008, obstruction in 2011, aggravated assault in 2014, felony shoplifting in 2013, simple battery family violence.
I told you, if they're crazy, you will get signs that they're crazy early on. This guy may or may not be a criminal.
in 2017, suspended license in 2017, aggravated assault in 2017, felony shoplifting in 2018, and possession of methamphetamine in 2020. So, Your Honor, he has a demonstrated history.
Felony shoplifting. My sister has so many theft charges that all of her theft is felonies now. Poor Beck is trying to sleep, guys.
Of drug abuse, and I think at this time an ASM level 1 would not be the appropriate level of treatment given his history.
All right. And this is an open plea?
Yes, sir.
All right, Mr. Callahan, I'm holding here your petition to enter a plea of guilty. You recognize this document? Did you read it, understand it, go over it with your attorney and sign it here on the second page? Did you answer all the questions truthfully?
I agree with that.
Did you answer all the questions truthfully? Did you sign the document freely, voluntarily, and with a full understanding of what you were doing?
Sir, yes.
You understand what you're charged with? Has anyone coerced you to enter a plea of guilty through threats, force, or promises?
Like people who post bad comments, they should get fisticuffs. I'm ready.
Are you now under the influence of alcohol or drugs? When you plead guilty, you give up certain rights. You give up your presumption of innocence, your right to have a trial by jury where the state will be required to prove your guilt beyond a reasonable doubt. You give up the right to confront the witnesses against you, to subpoena witnesses to testify for you, the right to testify for yourself and offer other evidence at trial. You give up the right to be represented by an attorney at trial, that being an attorney you hired or one that was appointed to represent you, and you give up the right not to incriminate yourself. By pleading not guilty or remaining silent, you would get a jury trial. Do you understand you have these rights and that you give up these rights by pleading guilty today? Have you any questions about the rights you're giving up or about anything regarding your case?
Yes, sir, I got
Both of my sisters are drug addicts, like full drug addicts. Name the drug. That's what they take. All of them. All of them. And they were gorgeous. They used to be gorgeous. I mean, I was the middle one. Yeah, my younger sister and my older sister. I'm the middle child. My older sister was like the girl everybody wanted to be in school. Back in the 80s, she had the big feathered hair and and they were both so smart. They were so smart. And now, oh man, oh my God. Yeah, they look really bad. I mean, they do. There's no other way to put it. They both look horrific. Drugs, guys, don't do it. Just drink beer. It's fine. Just don't over drink beer, but just drink beer.
You understand the rights you're giving up? All right, and you understand this is an open plea, so there is no negotiation, right? All right. Mr. Callahan then adds to count one, possession of a Schedule II controlled substance, that being oxycodone. How do you plead? And did you in fact commit that offense as you've been accused? I'm going to accept your plea of guilty, find you guilty, and find that you entered your plea freely, voluntarily, and with a full understanding of what you were doing. Do you agree? Mr. Boss, you agree?
Yes, Your Honor.
All right. Anything you want to say about sentence?
Yes, Your Honor. So what we would ask to be considered to impose is not significantly different than the state's recommendation. The only two things we aren't in agreement with is we would ask first to consider doing a $1,000 fine. Mr. Callahan really doesn't have much financial resources, so any kind of fine will be a burden on him and might set him up to fail. And the only other condition, Your Honor, we would actually ask you to consider not imposing DRC, just to consider all the time he served in custody, the sentence proportion and the custodial and punishment proportion, and not impose any kind of treatment.
Monica, your mom must have gotten your name wrong all the time when she was mad. I want to know, did she ever get it right when she was mad at you? Did she ever say Monica?
At this time, Judge,
First things first, I want to point out the underlying charge, this possession of controlled substance, is only because of an alleged single pill of oxycodone found. He wasn't found with any significant weight of pills, wasn't found with any significant methamphetamine or anything of that nature. It was apparently just a single pill. And because of that single pill, he spent 53 days in our jail, where if there was any substance abuse issues, which the state's alleging he has, he's been sobering up in the jail. Though Mr. Callahan's position is that he doesn't have any substance abuse issues. At most, he has a tendency to smoke some marijuana, but not to the extent that it's abusive. So he's adamant he doesn't have a pill problem. He doesn't have any real substance abuse issue. And Your Honor, even though he has spent 53 days in jail, so he has been clean. If he would have been willing to do a drug test right here now to show that he's clean. But I think
My mom, my grandmother had 21 kids, but only 17 of them survived. And my mom is somewhere in the middle. No idea. Do you know how many of my aunts and uncles I ever speak to throughout my life? 0. They're out there. I mean, I'm sure they're not all still out there, but a lot of them are still out there. But no. They are also, they like their drugs.
given he's been in jail, I think, it's going to be no surprise he is. But of course, if you're willing to do that and considering what to do with him for treatment or consider not having any treatment, he's willing to do that, Your Honor. History-wise, Your Honor, yes, he has some criminal history, but as far as drug history, other than some possession marijuana charges, the only other history he has is a prior meth charge back in 2020. He has no other drug history, and his position is after getting that charge. And I will say, Your Honor, he got out of prison about March of this year. He spent about 14 months in prison. So, Your Honor, given the fact that he spent so much custodial time because of that, he has not touched that stuff. He has not been touching that stuff. And I think the sentence and the charge reflects that again. He wasn't found with anything on him other than single pills.
Okay, so he was found with something on him. He wasn't found with anything on him except for one pill. He doesn't touch that stuff, even though he had one pill. Terry, you're the youngest of 4. I know this, right? All girls. Yep. Because I confirmed that. Yes, we know you're an only child. We can tell just by how you act. IKK.
So frankly, Your Honor, the fact that this case is about a single pill of oxy, we think just 53 days in custody. Although there's standard terms and conditions without treatment, it's an appropriate resolution. Of course, Your Honor, if you want to pose a substance abuse evaluation, he's more than happy to do that to prove that he doesn't have a substance abuse problem, and he's aware if you do impose a substance abuse, he'd have to follow the recommended treatment. I will say, if you are inclined to impose some treatment, logistically, DRC would be difficult. He doesn't have.
I would adopt you in a heartbeat. I would adopt you.
So it's going to be hard for him to go to DRC. So.
And Your Honor, I would just point out for the court that on cycle 43 of his GCIC, the reason he was in prison was a probation revocation on January 31st, 2023 for 1 year and 4 days out of Forsyth County. So he had already completed his prison sentence when he picked up these charges.
My sister did the same thing. Her daughter got pregnant, and then she's like, okay, hold my beer, and got pregnant. So the uncle is younger than the nephew.
What was the reason for his probation revocation, January 23?
It doesn't say, Your Honor, so it would have been a technical. I didn't see any new violations at that point. I'm not seeing any new violations since it's sentenced for meth, so it would have been a technical. Failed drug screen or something of that nature.
I think Ms. Johnson's trying to find out on her magic DCS computer. In objection to me letting her tell me what the basis of the revocation was to send him to prison.
No, as long as I can, I believe Ms. Johnson what she says, but as long as I have an opportunity to review the document.
I think it'd just be a printout, but if she can find it.
No, leave that backspace button alone, lady. Ma'am, whoever's doing it.
Yeah. I'm good. How are you, Greg?
Mr. Voss, why don't you and the prosecutor walk over there to Ms. Johnson. Before she tells me, she can tell you, and then you can decide whether you want me to hear it or not.
Yeah, he's been in custody since October 22nd, 2022 in Rockdale County. So it's going to be 12 months time to him, sir. He wants to close the case. He does not want a lawyer under any circumstances.
Come on, Georgia, let's go. Her hair is just so gorgeous. I've shown her in a couple clips in this seat, and her hair is so gorgeous.
Judge, it's essentially for, no objection.
No objection.
Okay. It's for failure to report each and every time. He hasn't been in compliance with his probation. He left the state without permission, failed to update his address, and there were multiple problems in Forsyth County based
Okay, so what would you guys do? I mean, he just can't follow any rule whatsoever.
on that.
All right. All right, anything else from anybody else?
Yes, I'll just say, Your Honor, it's not based on picking up new charges, failing drug screens, or that nature. He was homeless at this time, but Your Honor, in this time, he has a game plan to report. He's intending to reside around Dawson County. He's got a tent. He's willing to stay literally wherever as close as he needs to be to report to probations. So I would not be particularly worried about him failing to report on this matter, especially knowing what could be at stake given his history. And he, I think, is very motivated to comply with conditions, seeing as he knows the next step would simply be going to prison. So.
Mr. Callahan, listen carefully to the sentence because I'm going to give you some options. I think this is what either side's actually asked for. The sentence on count one is going to be 3 years with 53 days to serve. Credit for time served. I'll find you served your custodial time. You'll pay a $1,000 fine plus court costs and surcharges. Pay the $50 PD application fee, $300 reimbursement to Hall County or Dawson County for your attorney's fees. Report to probation. Perform 40 hours.
I'm the one that showed the barefoot ladies mucking out the stall, walking on the poop for you.
Community service. You'll have a fourth waiver, provide bodily specimens for testing and waive evidentiary foundations. Provide records releases, undergo evaluation and treatment for substance abuse, attend a minimum of 2 12-step meetings per week while you're on probation. Obtain your high school diploma or GED and show proof of that to probation. Provide a DNA sample as required by law. You'll avoid using or being in the presence of alcohol or drugs, being around others or under the influence or in possession of alcohol or drugs. Don't be in any residence or vehicle in which alcohol or drugs are present. Verify your prescriptions with probation. Be subject to a minimum of 2 drug and alcohol screens per month at your own expense at the direction of probation. And any money you spend towards treatment can be offset against your fine dollar for dollar as an added special condition of your sentence. And here's where you get a choice. I'm going to add the condition that you enter into, diligently attend, and successfully complete RSAT and all aftercare. However, if you can get accepted into a 12-month residential treatment program that's Thor approved, or alternatively North Georgia Works, and I would suggest that you try North Georgia Works, is for folks that are homeless, that need a job, and maybe have other issues. If you can get into one of those programs before you get on the bus to go to RSAT, then you may do 12 months of residential treatment at a Thor approved program or North Georgia Works. And that'll knock out the RSAT.
Elite, you got some trauma you need to unpack from your childhood. I liked it, Fozzie. I thought it was fine.
You'll remain in custody until transported to our side by the sheriff's office. You'll be responsible for the cost. So, Mr. Voss, if he decides he wants to try to do residential or North Georgia Works, you just need to make that happen and then let probation know so we can take him off the list to go to our side.
Yes, sir.
All right. And Mr. Callahan, we just want you to be drug-free and have a job and be successful, right? I don't really want to send you to prison, but I just don't want you camping out in Dawson County with no treatment either.
We'll say he's already willing to do a Thor approved. We just want to include that on the sentence. He remains in custody until a program is found for him.
All right.
Or North Georgia Works, or I guess any homeless place, or just North Georgia Works, Your Honor.
North Georgia Works or a Thor approved program. So I guess we can just take off our side and just say do 12 months Thor approved or North Georgia Works. All right. North Georgia Works might be good for you. I mean, it's religious. You got to be ready to deal with that part, but they'll help you find a job and give you a place to stay and help you get a bank account and all that kind of stuff.
Kind of real sick mom, sir. I really like to see her before I keep on in the hospital. Turn something in or something like that. My mom is
I honestly have watched this judge a lot, and I do not remember her at all. And I don't know what she's doing there. I have no idea. This is obviously the court reporter. This must be the clerk. There's, plenty of security. I don't know what this lady is. Maybe the coordinator. Who knows? But what would this lady be? I do not know. And chat is going crazy, so I'm trying to do both. Court and chat.
We'll help you find a place. We can usually get people in a program fairly quickly. Okay, so.
Yeah, once you get in the program, they'll give you leave to go and do stuff you need to do. All right.
I put those stickers on everything, everywhere I go. Yes, I do. I absolutely do. My favorite stickers, though, for bars, and if I go into a bar with a male friend, I make them put it in the men's room, too, is voice activated. Say paper towel, please. And I pop that right on the paper towels dispenser. I love it. I just think it's the greatest thing ever. No, she's not a judge in training. They don't stick them on the ground. They put them right beside them. Hi, David.
But you got to, you have history of not reporting, so I want you in a program before you leave the jail. All right, thank you. That'll be a sentence.
Okay, in my family, it's about to be Christmas. Christmas Day, I am scheduled to see 0 people. Because we've been fighting so much this year that I don't have to see any of them. Now, I talked about my niece Jessica. I work with her. My nephew Michael and Jessica's son Connor. Those 3, besides my children, we all did a Secret Santa. So we only have to buy one gift, and we don't have to buy everybody a whole bunch of gifts. That Secret Santa is until like January, and January is like 100 years away, so I don't even have to worry about Christmas until January. Now, I am, however, my mother's birthday is on Christmas. I am, however, even though I'm not speaking to my mother at all right now, not even a little bit, going to get her Christmas, and I'm going to get her a birthday gift, and I'm going to put it on my porch. Why? Why am I going to put it on my porch? Because she comes by once a week to pick up her mail from the porch. And if we want to give each other anything, we leave it on the porch. So I'm going to leave her mail and a birthday present and a Christmas present on the porch. And then I don't have to deal with anything. I send her rent through Cash App. I really want to move so badly, but I can't because she needs me to live here. I don't know. It's just confusing, but yeah, at least the porch is there for me.
And Your Honor, Miss Ashley Clark is signed up and ready. Pleasure.
All right, Ms. Clark, come on up. Is Mr. Witt signed up and ready?
Yes, Your Honor.
He'll be next.
Go back to the office for a while. Because Clark is out now.
Right there.
She takes
Is
it.
Mr. Witt back in custody?
Just gotta go sign it.
He's out of custody, Judge.
Okay. Where's Mr. Witt? Oh, okay. I'm gonna tell everybody the rights to give up. I just wanted you to be here so you could hear them.
Yes, sir.
Have you already heard them?
Yes, sir.
Ms. Clark, did you hear me tell you the rights you give up when you plead guilty?
No, sir, I wasn't in here, but my attorney did go over it with me.
Okay. I'll do it for the record. So let me tell you that, and everybody else that's in here, let me tell you about the rights you give up when you plead guilty. When you plead guilty, you give up certain rights. You give up the presumption of innocence, your right to have a trial by jury where the state will be required to prove your guilt beyond a reasonable doubt. You give up the right to confront the witnesses against you, to subpoena witnesses.
I did ask my family if we could move to Texas. I did. They're at a no right now, but I'm working on it.
To testify for you, the right to testify for yourself and offer other evidence at trial. You give up the right to be represented by an attorney at trial. That'd be an attorney you hired or one that was appointed to represent you. And you give up the right not to incriminate yourself. By pleading not guilty or remaining silent, you would get a jury trial. When you get up here at the end of your plea, I'm going to ask you if you understand the rights you're giving up by pleading guilty. If you have any questions about those rights, make sure you ask me at that time. All right, let's proceed with Ms. Clark.
Yes, Your Honor, this is Dawson County Superior Court Case number 2024 CR 0836, State of Georgia versus Ashley Victoria Clark. Ms. Clark is accused on one count of felony theft by shoplifting by amount. Counsel,
Is that a jail costume or is that what she's wearing today? I mean, the only reason I ask is because the shoes are black. And normally when I see the shoes, they're orange with the suit. So is she just choosing to wear this outfit today? Or is that a jail uniform?
waive formal reading of the accusation.
So waived.
And do you stipulate to a factual basis?
We do.
Your Honor, it's going to be recommendations state on count one. Sentence will be for 10 years on probation with a $2,000 fine. Conditions will be report to felony probation, 100 hours of community service, shall enter into and successfully complete the mental health accountability court program. She's currently enrolled in Cobb County, Your Honor. Fourth Amendment waiver, specimen admissibility, no contact with Alta in Dawson County, records release. She's to undergo the cognitive skills training, diploma, GED proof of full-time employment, banishment from Dawson County. She's to provide a DNA sample as required by law, avoid alcohol and drug use, verify prescriptions, random drug.
That's what I was thinking, Kelly. She has a belt on, but what if it's not a belt? What if she's handcuffed down at her side? What if that's a security? Hey, where's security? Security, tell us. She could be handcuffed down to her side. Because look, how many belts do you have that have like this big ring in the back? I have 0. So, I don't know. We'll see. We'll see when she walks.
Alcohol screens. Counsel, is that the agreement as you understand it?
It is.
All right, Ms. Clark, I'm holding here your petition to enter a plea of guilty. You recognize this document?
And there we have
Did you read
it.
it, understand it, go over it with your attorney and sign it here on the back?
Sir, yes, sir.
Did you answer all the questions truthfully?
Yes, sir.
And did you sign the document freely, voluntarily, and with the full understanding of what you were doing?
Yes, sir.
Do you understand what you're charged with?
Yes, sir.
Has anyone coerced you to enter a plea of guilty through threats, force, or promises?
No, sir.
Are you now under the influence of alcohol or drugs?
No, sir.
Were you present when I told you the rights you give up when you plead guilty? Just now?
Yes.
You have any questions about those rights or about anything regarding your case?
No, sir.
All right, ma'am. Then as to count one, theft by shoplifting felony, how do you plead?
I wouldn't wear a belt with that.
Did you in fact commit that offense as you've been accused?
Yes, sir.
You're going to accept your plea of guilty, find you guilty, and find that you entered your plea freely, voluntarily, and with the full understanding of what you were doing. Do you agree?
Yes, sir.
Mr. Murphy, you agree?
I do.
Anything you want to say about sentence?
Your Honor, I would just say that she has been enrolled in the Cobb County Mental Health Program for 6 months now. I understand from Ms. Clark, she's reported to me that she's had no violations once she's there. It is, as Your Honor knows, a very intense program. She's at a counseling center every morning from 9:30 to 12:30 in Cobb County, sees the judge every Thursday. In addition to that, she works at a Courtyard by Marriott.
Oh my God, she likes food. Oh my God, how horrible. I love food.
From 3 to 11 p.m. So she is doing some intense work for herself, better herself. She was in a mental health crisis when she was arrested in this case, as well as another one down in Cobb County. But she does have stable employment. She has stable housing where she's been for 7 years in Ackworth. She's undergoing drug tests. She has a curfew. She has home visits, daily classes, and is doing well.
Guys, what the hell? What the hell? No, Elite, you're not fat. You have fat because you like food. You are not fat. You have fat. Leave her alone. Look at her. Leave her alone.
With the treatment that she's receiving for the mental health problems. So we would just ask the court to accept the plea as negotiated and allow her to continue her mental health court in Cobb County.
And Ms. Clark, do you pay a fee, like a weekly or monthly fee to the mental health court?
Yes, I do.
How much do you have to pay?
So every week we have to pay $10, and then I have restitution and court fees. So that's $5,000. So since I've been working, I've paid $2,000 so far. So I try not to get behind because they give us sanctions if you get behind. But I've been doing the best as far as keeping it up.
All right. The sentence negotiated is going to be the sentence of the court with these two caveats. I'm going to reduce the fine to $1,000, and any money you spend towards treatment can be offset against that fine. So keep track of what you're paying to the mental health court and show that to probation, and they'll give you credit for it. Also, when you graduate from the mental health court, I'm going to give you credit for the community service that was ordered, the 100 hours community service.
Yes, sir.
And if you complete the mental health court, I'm going to give you credit for the cognitive skills class, because you're going to get more intensive treatment in mental health court than you would with that little class.
Yes.
All right? So the key to all this is do good in your mental health court there in Cobb County. It's going to take care of a lot of these issues if you just do good what you're supposed to there in Cobb County.
Yes, sir.
All right? You want to accept that sentence or withdraw your plea?
I want to accept it, sir.
That'll be the sentence of court. Good luck to you, okay?
Thank you.
Keep working hard.
Thank you, Your Honor. Subject to probation, may we be excused?
Yes, sir.
Okay.
Have a good day. All right, Mr. Witt, come on down.
Did you give her credit for the community service or just the cognitive skills?
Thank you, sir.
Sorry, I was texting Fozzie. Fozzie and me like to do this thing when I'm working is text questions.
Your Honor, my apologies for being late.
That's all right. We have plenty to do, so it's not a problem.
All right. If I may, Your Honor.
Yes, sir.
This is Dawson County Superior Court Case number 2024 CR-0592, State of Georgia versus Emmett Dillon Witt. Mr. Witt was originally indicted on count 1, aggravated child molestation, count 2, aggravated sexual battery, count 3, child molestation, count 4, sexual battery against a minor, count 5, possession of drug-related objects. And I'll get into this in a minute for the reason, Your Honor, but counts 1, 2, 3, and 4 will all be reduced to simple battery. Counsel, do you waive formal reading of the indictment?
I do.
Do you stipulate to a factual basis?
I do.
I'll start, Your Honor, by saying that while the victim's mother is very upset with this plea and the resolution, she understands why we're doing it. She is present in court. I won't say she's in agreement, but she understands that this is what we have to do to resolve the case. What was originally alleged are essentially two different incidents. The first was they were playing hide and seek, that a defendant and the victim or something like that went upstairs alone in a closet, when the mother went looking for them, he held the closet door shut for a bit, jammed. When they opened it, there was some ruffled hair. The child was red in the face. No allegations were made at that time. The mother didn't think anything unusual of it. A few weeks later, the defendant was alone in the kitchen with the alleged child. She had an accident, or at least that's what the defendant said she had. Came out and told the mother, made a swiping gesture to indicate there was an accident. When the mother went to change the diaper, she noticed that there was a ring of fecal matter around the child, thought that was unusual. That's when the investigation commenced.
I am so sorry. I did not know that this was here. I recorded and I did not realize. I'm going to pass this guy. Screw this guy. I hope he sits in jail. All right. I'm so sorry. All right. I did this for Beck. I I usually don't show you guys that stuff. I go through, you don't understand. I get like 7 of those a day. Going to get content for this stream, I go through at least 7 of those a day. It's horrible. It happens all the time. If I could just describe to you how often that happens, you would be horrified. So this next one, I got this for Beck, and Beck went to sleep. We're gonna go since we don't have a Judge Fleischer clip to play right now because he took them down. Sorry, I was reading. Then we're gonna go. We're gonna do a little bit of Judge Wolf. And I don't know. I didn't get to see this. I hope it's good. He's always good, though, isn't he? So we're gonna play Judge Wolf for a little bit. Oh, I gotta unmute it. Hold on.
Dan Henry Lee,
There we
the
go.
fourth versus the Enclave of Pleasant View Homeowners Association Board of Directors, and I.
No, we're not doing that. I wonder if we'll see Rebecca in here. Yeah, we can do OJ today. We can do anything today. I have off today. Let's go past that. Let's go forward a little bit. We'll start here. Sorry I showed that. Just move past it. Move past it. Mel, don't do anything. You're fine. There we go. Now he'll start. Okay. Here's what I know. He's just taking a break. Okay? Everything's fine. It is absolutely nothing any of us did. Because believe it or not, what we do doesn't affect him as much as we think it does. Right? He's a judge. He's in a courtroom. It's not for entertainment purposes that he puts his stream up. I know people think it is, but it's not. So he is actually taking a break from the YouTube side of what he's doing. And it's fine. He's a judge. He can do whatever he wants. Nobody did anything wrong. I guess I should also say if you hear other people say other things, they are wrong. Don't listen to them.
I'm back on the record in the Donald Howard Walker versus Elizabeth Diane Walker. And I want to make a few findings on the record before I tell you what I intend to do in this case. Number one, there was an order of protection that was filed in this case by Donald Walker. I believe looks like it was filed in July of 2023 in general sessions and then transferred to this court because of pending divorce. And that petition for order of protection sets forth under oath the following grounds for the order of protection. Diane was mad and has been depressed. Diane told me she was going to kill me and anyone affiliated with me. Number two, Diane told me she wanted me dead so that she could have all of our money. Number three, took the safe key that has guns and important paperwork. And I had my medication, hid my medication from me. Diane has a family history of mental illness, and it goes on as that. And an order of protection was then heard by this court on the 22nd day of January 2024 by me. And this court made the following findings. Upon the testimony of both the defendant, Elizabeth Diane Walker, and the plaintiff, Donald Howard Walker, exhibits presented and review of the pleading, the court finds that the defendant, Elizabeth Diane Walker, presents a credible threat to the plaintiff, Donald Howard Walker, and has made statements threatening the plaintiff's life. Further, from the proof offered, the plaintiff owned the home where the parties resided prior to their marriage, and due to several health issues, he should be awarded the exclusive possession. Additionally, the defendant, through her testimony, did not present sufficient evidence to establish a need for spousal support, nor did she establish that the plaintiff had an ability to pay. Then it went on to say that an order of protection would issue against the defendant, and she would not abuse or threaten or to abuse the plaintiff, the petitioner, Donald Howard Walker, not to stalk or threaten to stalk and so forth. And went on talking about all of the limitations as imposed under an order of protection. Then it went on in paragraph 2 of that order. It is ordered, adjudged, and decreed that based upon the sworn testimony of the respondent for admission found in sworn discovery responses, and the finding of the court that the plaintiff's current medical condition necessitates, the court awarded a judgment on the pleadings and grants an absolute divorce to the plaintiff on the grounds of inappropriate marital conduct of the defendant, and hereby restores both parties to all rights and privileges of unmarried persons. The issue of division of assets and other related matters is reserved pending a final hearing in this court. That was the order of the court that was entered. And then what I have before me is a motion to essentially vacate that order and dismiss this case based solely upon the fact that the plaintiff is now deceased. I have reviewed the McMahon versus Butler case that was cited. It is a 1986 decision of the Court of Appeals, and it is an unreported case as far as I can tell from this, and therefore unreported cases are not necessarily persuasive for the court or controlling for the court. They are instructive, but as was pointed out, there are several exceptions to this general rule about the death of a party in a divorce case being grounds for the dismissal of any temporary order. Number one, Rule 54 does provide, as has been quoted, that there is a provision for an order to be entered, but it also allows that upon an express direction of the entry of a judgment where there is no just reason for a delay, in the absence of such determination, direction, any order that in any other form of decision, however designated, that adjudicate fewer than all claims or rights, liabilities of fewer than all the parties shall not terminate the action after any claims of the parties, and the order or other form of decision is subject to revision at any time for the entry of the judgment adjudicating all the claims, rights, and responsibilities of the parties, liabilities of the parties. So the question becomes, did this court's finding that the plaintiff's medical needs and the undisputed facts or the court's finding of facts as to the basis for the granting of the divorce, where both parties sought a divorce, does that constitute a finding under Rule 54 as to there is no just reason for delay in express direction of the entry of a judgment? That would make it more of a final judgment on the issue of divorce rather than a interlocutory ruling. The court is of the opinion, too, that there is a need for further investigation as to the state of the law in the state of Tennessee rather than, I don't dispute that the Stevens have produced this case, but I'm also not convinced that there might not be some other authorities. So I'm going to take this matter under advisement so that I can further investigate it and apply the law to these particular facts of this case. But I'm going to also allow both parties 30 days in which you may file any additional authority, research, authority, case law, or anything else. You'll have 30 days to file that with the court, and then thereafter I will make my ruling. Let's go ahead and set it for March 17th, just to say, so that I can announce my ruling rather than have to issue necessarily a written order, although I may do so.
March 17th.
March 17th. That's one of March 17th.
Thank you, Your Honor.
I'm not at all opposed to saying that it may be that this case is controlling, but I want to see if there's any more current law out there. Because Court of Appeals oftentimes changes their position on certain things, especially where it's an unreported case. So, thank you.
Your Honor, if we could, because there is, I think there's an issue, I would request, there's an estate matter pending, motion pending in the estate matter that should be held in abeyance pending this court.
Is that on the docket for today?
It is, Your Honor. There's an exception to the file, the claim, but it's directly related.
The claim is by Elizabeth Diane Walker for a homestead exemption, elective chair, annual year spouse between the board and attorney fees. And then there's also petition to contest the will.
I don't believe that's on your docket, Judge. Dang.
All that is.
Clearly, it would seem to me, it seems I don't want to foreclose your argument, but it would seem to me that until I make a final ruling on the motion, that that's premature to consider their exception to the claim.
Yes, Your Honor.
If I uphold her motion, then the claim may be verified and it may be sustainable. If I deny her motion, then it presents a different issue. So we'll take the matter off the docket and put it on the March 17th docket.
Thank you, Judge.
You know, if I could, we had we're discussing the, our case, and if I could be excused. Second.
All right, I'm sorry.
I don't know on the query case, if you would just pass that just a second. That's when we were discussing that. I don't know if it's there.
The Dalaveras. All right. Now let's go to Butler versus Butler. Do you have an agreement so the spirit of Christmas survives?
Yes, Your Honor. Your Honor, so we have a temporary agreement to resolve the motions that are currently pending, for the most part anyway. We have an agreement that, and I'll write this up for the court, that the father will have parenting time from Wednesday at school dismissal to a return to school on Friday. And then in the other week, in the alternating week, he'll have parenting time from Friday at school dismissal to a return of school on Monday. We have a Christmas schedule that I'll put into the order that, you know, is by agreement. And then I have a motion pending for the sale of the real estate and a motion to relocate. Right now, I'm going to strike those motions and we're going to see if we can maybe get those things worked out together. I think that's about it. I also have a motion for a scheduling order, but I think we can probably come up with an agreed scheduling order.
Your Honor, the only thing my client wants to make sure the court is aware, he still can continue to seek 50/50 time. He's just agreeing to this.
This is an agreed temporary order that doesn't foreclose either one of you from any position that you may have in the future regarding the petition. Both of you are the parents. I hope you both work together to try to co-parent your child or children, but I'm glad you were able to reach an agreement, at least at this juncture, and it's not going to foreclose you to change your position if that's necessary.
We have two other things I forgot, Your Honor. One is that there's a pending, well, there's not a pending, there's a general sessions judgment that part of the terms of probation are no contact between the parties. We have agreed to reach out to the district attorney's office to attempt to modify that with the district attorney's agreement that they can have communication by text, and that also the father can access some outbuildings at the marital residence to get some of the things he needs for work.
Well, obviously, that's up to the
Right,
general
we're just
session.
letting you know.
Yes.
That's the plan.
I think the way the sheriff's department has been handling those, we've got to have a court order with Your Honor also. They've been requiring.
Put it in the order that this court affirms that upon the general session judge modifying those bond conditions, then this court will allow that.
Thank you, Your Honor.
Perfect. Thank you.
Thank you. We're ready on, Mr. Roberts is outside on the Prairie case, is that correct? And that brings us to the following case is not on for the There's nothing to hear. So we're down to the Delaveras and the McCrary case. No. All right, well, they're talking about the remaining cases, so I'll step off and I've got some orders to sign, but as soon as they are ready to proceed, let me know.
Beck, I put this on for you, but he's not being Judge Wolf today. All right, we're good. Guys, thank you so much for coming out today. I so much appreciate it. I hope you had fun. I hope you had a little bit of, I don't know, something, a getaway before Christmas begins and you have to have fights with your family. I am going to do OJ after this. So if anybody wants to hop in for OJ, it's going to start almost immediately. If not, I hope you guys have the best Christmas ever. Thank you so much for coming out. I really, really, really appreciate it. Yeah, I'm going to be on tomorrow. Fozzie doesn't let me have Christmas off. Fozzie says my next day off is 2028. Yeah. I think you should all DM Fozzie. Every single person in here, DM Fozzie and tell him I need a day off. No, let's watch OJ. I'm going to do OJ. Thanks, guys. See you later. I just got an error message. Stay in the audio until the outro video finishes playing or the broadcast may not end properly. Okay, whatever you say.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's Sean. In a way, there's no alarm. Screaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. Wicked streams, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted, Sean. In a way, there's no alarm. Screaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh